In this video, we're going to discuss the guidelines for statutory maintenance in the state of Illinois. So basically, several years ago, the Illinois legislature enacted amendments to the maintenance law, passing a series of guidelines for courts to use when determining maintenance awards. This arose out of the fact that courts in Illinois were entering very different maintenance awards from county to county and even from judge to judge for similar facts. So, for example, somebody making $200,000 in Southern Illinois was paying much less or no maintenance, whereas somebody making that much money was paying a substantial amount of maintenance in Cook County or Chicago. The idea of the guidelines was to create some type of uniform system for maintenance calculation to give litigants, parties involved in divorce and their attorneys and judges, some structure and framework in terms of what maintenance awards should be in a given case. So let's talk about those guidelines. First, guideline maintenance applies in cases where the combined gross annual income of the husband and wife is no more than $500,000. First, with the guidelines, the court is to make a finding that the award of maintenance would be appropriate. And that has a lot to do with the length of the marriage, the amount of income made by both parties, and the asset division set forth in the potential or the upcoming divorce. So assuming that the court determines maintenance is appropriate, and I can tell you in most cases where the guideline formula would result in payment of maintenance, in our experience, the courts will award maintenance following the guidelines. The court will calculate based on the guideline amounts. So we're going to go forward with the guidelines. The amount of maintenance under the statute, which is 750 ILCS 5/504 in the Illinois Marriage and Dissolution of Marriage Act, the amount of maintenance is calculated by taking 33 1/3% of the payor's net income, not gross income, minus 25% of the payee's net annual income. So first, a little discussion about that. When we say net income, we mean net income in the classic IRS, basically IRS definition, that is taking the gross income minus calculated income taxes to come up with net income. Now, in complex tax circumstances, there can be some debate about what the net income of a person should be. And one issue that can come up also in more complex cases is income being added back into the payor's income for support purposes or for payment of maintenance. For example, if someone has a company car, if somebody is making 401k contributions, those types of dollars are typically added back into their income to calculate proper support. So those are issues to discuss with your attorney when dealing with maintenance calculations. That is, are there any extras the person is receiving? Are they holding out money for retirement contributions? And should those things be added back into income to calculate support? So basically 1/3, 33 1/3% of the payor's net income minus 25% of the recipient's net income is a base number for maintenance. Now, there's some caveats with this. First, there's a cap involved, and the cap is 40% of the combined net income of the parties is the cap for the recipient's maintenance award. How that works is the income of the recipient plus the maintenance cannot exceed 40% of the combined net income of the parties. So when we typically run maintenance calculations, we will run the numbers, look at the formula, run that calculation, and then also see what is 40% of the combined net income, and then see where that falls with respect to the maintenance plus income of the recipient. And it will reduce the maintenance award to the recipient to that level if it's higher. So next, people want to always know, how long will the maintenance last? Under 1B of 750 ILCS 5/504, the duration of the award is based on the length of the marriage. Now, first, when we're talking about length of the marriage extends from the date people are married to the date the divorce case is filed. That actually was an open question when the statute was first enacted or amended, and that later got the loophole was closed by the legislature a couple of years ago. So made it very clear that the marriage technically ends for the purposes of maintenance calculation on the date the divorce case is filed. This prevents people from dragging out a divorce case just to get more maintenance. So if you look at the statute, and instead of me belaboring the point with the percentages, as the marriage gets longer, up to 20 years in length, the percentage increases of the length of the marriage to calculate length of maintenance. So for example, if the marriage is less than 5 years, it's 20% of the length of the marriage. If it's around, if it's just under 9 years but less than 10 years, it's 40%, for example. And then getting up near, if it's 19 to 20 years, it's 80%. If it's 20 years or greater, the length of maintenance is known as indefinite. Indefinite does not mean permanent. Indefinite means until the person retires or until one of the termination events for maintenance applies. So the person won't be paying maintenance for the rest of their lives. They'll be paying maintenance typically until they retire. And the retirement terms are set forth in statute and also in people's divorce decrees as well. And you can modify the terms of the divorce statute in terms of maintenance termination by agreement in your own divorce decree. And we'll get to that in a little bit. So a court can award maintenance not in accordance with the guidelines. That takes an application of specific factors that are set forth in the statute, and that's not something we're going to talk about here. That's beyond the scope of this conversation. One thing I do want to mention is the concept of imputed income. The idea of imputed income is, what if you have a situation where the recipient either wasn't working or they're capable of working, but they're working in a lesser job than they're capable of. So they have a law degree, for example, but they're not working as a lawyer, they're working as a librarian. And nothing wrong with that. Just the person is earning $25,000 a year when they could earn $100,000 a year potentially. This can be a debate in divorce cases, and this is something that you'll see disputed in divorce cases. Courts will typically impute some income to a recipient if they have no income. The typical number you see in our experience is minimum wage, somewhere between $17,000 and $20,000 a year as an imputed income figure. Now that could go up or down depending on the circumstances, the employment capacity of the person, their employment history, and their health, things of that nature can alter that. But that's the idea of imputed income. The court will essentially insert that number to use for that 25% calculation if the person is earning no income or a substantially reduced income below what arguably they could earn. Let's define gross income in the statute and net income. Gross income is income from all sources. That means income from assets, income from your employment. What common misconception is, well, this is just job income. Well, that's a lot of times what happens, but there may be people receiving substantial income from investments such as rental properties and other things, and the court will consider that in terms of all income for support purposes. Net income uses the meaning provided in Section 505, which is the child support statute, and that's essentially net income less properly calculated federal and state income tax. There are really a couple types of maintenance. One is fixed term maintenance, and that is maintenance, as I'm saying here, for a fixed period of time. The court can designate maintenance for a fixed term, and once the maintenance term ends, maintenance is barred. Or, as I've said, after you have a 20-year marriage, typically a court will order indefinite maintenance, which is maintenance that has no termination date, but can be terminated by operation of law, by a motion brought by either party if they meet certain criteria, or by terms set forth in a settlement agreement. There's also a concept of reviewable maintenance in the statute, and a reviewable maintenance is maintenance that may have a termination date, but if the party receiving maintenance desires, they can bring a motion to seek an extension or review of that maintenance if they meet certain qualifying conditions. One thing I wanted to mention about maintenance also is the court can order that maintenance be secured by life insurance. And that is, the concept is, if someone dies, they're no longer able to pay maintenance. Therefore, the concern for the legislature was, well, then that person is left out of luck without any support. The court can order the use of life insurance to secure maintenance in certain circumstances. And you'll see that's fairly common in most cases. And keep looking for more informative content from us in the future.